Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Mary Ann Petrie. You can find me on dismantlingfamilycourtcorruption.com. You can find my books there, and they are also available on Amazon. Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, Cry Out for Justice, Poems of Truth, Raised by These Wolves, How Family and Federal Courts Are Failing Our Children, and soon to be released, Raised by These Wolves, Volume 2, Child Trafficking Through the Foster Care and Court Systems. Feel free to buy me a coffee to help keep this podcast going. I have a return guest. I'm very happy to have Jay Rosenthal, a founder of CPSProtect.com, back on. And he was last on season three, episode 87, season 4, episode 73, and season 5, episode 117. The last time he was on, we talked about Hogan versus Cherokee County, North Carolina, and the bigger social problem. And today we're going to talk about this really awesome case where this person got reunification with their child in record time. And usually it could take a year to over 2 years to get reunification, and this person got it within 4 months. We're also going to talk about the Chevron deference or doctrine. And I welcome you, Jay Rosenthal. How are you?
Thanks. Glad to be here. Again.
So how did you get that case so short in a short time span? How did all that play out?
So, to be clear, short is relative. Yes, removals in CPS cases happen pretty quick, but the rest of the case goes slower than a sloth. So, when we talk about reunification, or a quick reunification, assuming the removal is the court does end up remanding temporary custody to the commissioner of the state or municipal CPS agency. It, lightning speed for reunification is considered 6 months. This particular case, this was in Pennsylvania. Uh, reunification from removal to reunification, 18 weeks, which beats what is often considered lightning speed by about 6 weeks. That is phenomenal.
Mm-hmm.
And that is obviously 18 weeks of time with your child in foster care is enough to have potentially lasting consequences. So it's certainly not ideal. But if my choice is 18 weeks and 52 weeks, I will choose 18 weeks every time.
Exactly.
Not that, again, not that that's a particularly good choice, but into the meat of it. This, so this subscriber to Urgent Assist, that's our direct-to-consumer offering at CPS Protect Consulting Services. They had been a subscriber for a previous case, before a previous case
Mm-hmm.
in which we had managed to help them. We were we were actually there by phone, interacting with them and the CPS workers, and basically stopped them short. I think over 2 visits, if I recall correctly, they spent maybe 45 minutes total before they were able to substantiate. They just didn't have enough information to go anywhere.
Right. And when you
So,
were on the
mhm,
phone with this person and CPS, the caseworker was actually begging to get off the phone. Isn't that right?
it's
Or to leave.
it's been so long at this point. I haven't really reminisced about it in a long time,
Oh, I have.
but yes, that was a very interesting experience. But ultimately, I care less about the, as amusing as it was, uh, I care less about what how the worker actually reacted, and more that we were successful, the allegations were unsubstantiated, and that was the end of that. Now, granted, that worker in particular, based on my profile of him, he was just out of college.
Mhm.
He had been on the job less than 6 months. Um, really, particularly unsteady on his feet, so to speak. He had not gotten his whatever the CPS equivalent is of his sea legs
Mhm.
at the time. So it, normally, if a CPS worker or a CPS investigator is on the job long enough, either they'll figure out the bureaucracy enough uh, to basically not react like that. Uh, they'll leave before they get to that point, or they will uh, they will detach. They will emotionally detach from what's going on, because if they are emotionally invested, it will hang so heavily on them, essentially through vicarious, what they call vicarious trauma, which is a legitimate thing. It's one of the reasons, amongst many, that there is such a high turnover
Mhm.
in CPS, at least with when it comes to the frontline employees. So you have to emotionally detach to even survive
Mhm.
in some of those cases. And so in that case, it's very hard to go and scream at somebody or lose your cool or betray your emotions. The but back to the case in question. So this family, they were already a subscriber to Urgent Assist, and we already had a pre-existing relationship. There was already that degree of trust, and CPS was called again uh, because the child was had been out of control. They had a safety plan they were working on with their that they'd done with their provider. It involved restraint, and well, when it comes to mandated reporters, well, it's always the what if. And so they show up, and they're not, they show up particularly aggressively.
Mhm.
Um, when it comes to what's reasonable, when it comes to restraint, such a, how do you put it, it's such a murky
Mhm.
area in a lot of respects. There aren't many people who want to touch it,
Mhm.
that particular issue. The child was not initially removed. They basically said, after they were unsuccessful in intimidating the family, they actually didn't want to speak to us. So, like, because of what happened the time before, they're like, we're not going to speak to someone with on a toll-free number.
Mhm.
Um, and actually, against our consultant's recommendation at the time, uh, the client actually hung up and tried to wing it. But fortunately, we'd worked with her so much, so heavily on the initial case, she had some idea of what she needed to do, and she did survive. But there was a cost to that a little later on, because basically they said they were going to provide services, they never did. So it was basically, if anything happens, just call law enforcement. They'd asked law enforcement if they could do the restraint, if it was legal for them to do. Law enforcement, not knowing any better, basically said yes. CPS found out that the restraint had been used again in the meantime, and then used that to say the child is an immediate or impending danger or imminent risk, and did a removal. Now, here's the key. We our consultants, me especially, just because I'd taken a special interest in this case, and this was a subscriber who'd been with us, you know, earlier in our existence. She'd
Mhm.
taken a chance, and
Mhm.
so I'm particularly sensitive to those who, uh, who put their trust in, who have put their trust in us particularly early. So we were there from the first moment, the first second of all this. There was
Mm-hmm.
already that pre-existing trust, and not a single mistake of the at least of the most common ones that most families make were made. She was we made sure she was on top of everything, that in conjunction with us, she had the right team behind her, that she was taking the right steps in every respect, that she was doing what CPS would eventually tell her to do and putting the right services and the right things in place before CPS could even do it.
Mm-hmm. Mm-hmm.
We were working with her to predict exactly what CPS's next 5 to 10 moves were going to be down the road and preempting them continuously so by the time CPS started to started to cling by a thread, they didn't really have anywhere else to go. They were
Mm-hmm.
boxed in. A lot of families, when a removal initially happens, they get very belligerent. They get very argumentative. They try and push back. They say, no, you can't come in here. All this. Sometimes and I see this more often than you think. They end up getting arrested uh, for assault or something else for maybe they're pushing back or there's something with with the cops there,
Mm-hmm.
or even if they're just nasty, it's all of a sudden, look at this parent, look how they reacted when they came in, and all of a sudden you're painted with a bad brush just by the way you acted in that moment,
Mm-hmm.
regardless of the stress you were under. She kept her cool. You
Mm-hmm.
told her, okay, there's nothing that you can do in this moment. I know it's hard. Prepare your child for this. Prepare your son for this, and you're gonna have to do this. You're gonna have to litigate it in court. Um, but uh, fighting isn't going to make it any better, and it's not going to create a different result. And that's one of the hardest things for a parent to
Mm-hmm.
actually maintain in the moment, just because it is that heartbreaking and that anxiety inducing. The idea that someone can easily remain calm in a situation like that, you have to be devoid of all emotion.
Right.
So she ended up handling that extraordinarily well. And then immediately went and started doing a deep dive, learning as much as she could, trying to get an attorney when she realized, and unfortunately, this is a real issue. A lot of attorneys, most attorneys who even deal in child welfare, private attorneys in particular, they don't have the paralegals to do the research. They don't have the staff. They don't have the personnel to actually prepare for a hearing the next day or 2 days later. They really don't.
Mm-hmm.
And I, at the same time, I often hear a lot of attorneys who end up saying, well, we really, they haven't taken you to court. So call us when they take you to court. And that's by then it's like it didn't have to get this far.
Mm-hmm.
And then there is no law school in the country that has a class on child welfare law. Not a single one. Not child welfare law, not child welfare specific litigation.
Mm-hmm.
Nothing. So unless you have a lot of experience and a lot of success as an attorney litigating child welfare cases, and there are some who have that experience at this point. But a lot of attorneys do not really understand how to successfully litigate a child welfare case. They understand what litigation is and they understand what they're fighting, but they don't understand A, the nature of it, or B, what happens in between hearings.
Mm-hmm.
They really have a very poor understanding of that. And that's how you end up 6 months to a year later, seeming like you don't have the progress that you really want to have. They don't actually fully understand the nature of this. And it's really sad
Mm-hmm.
that while many attorneys excel or can do really well in other areas of family law and other areas of law, criminal, constitutional, contract, trademark law, the list goes on. Um, they really, most attorneys do not have a good handle
Mm-mm.
on child welfare litigation. And so what ended up happening, the father, they're together. The father was represented by uh, a private attorney that they got to take the case after the first hearing, and mom represented herself pro se. And the irony is, mom was the better attorney. But it's because she was able to learn very quickly. She had a friend who was a federal prosecutor who she was able to lean on. She was able to work with the father's attorney and learn a little bit more on the fly. And so and because when you represent yourself pro se, you're not held to the same standard as as a licensed attorney is. She
Mm-hmm.
was given a little bit of leeway. So it was a combination of her getting the right team together, her her being proactive and really learning a lot of this, and working with us to preempt the
Mm-hmm.
CPS agency on whatever they could do. If they were going to recommend services for the child, she got those services in place. If they were going to recommend she get certified and restrained, or she get this evaluation or that evaluation, she got it done. If it was a change in the safety plan, the change in the safety plan was done. She got the right experts in place.
Mm-hmm.
She this but these are the kinds of things that she did, because a lot of times you see in child welfare cases,
Mm-hmm.
the attorneys will cling to to the most frivolous thing that they can find. And I went over this on the last episode. It's because the way an attorney is measured is the way how good an attorney is, the way their efficacy is measured is based on their conviction rate, their adjudication rate. And so, no different than any other attorney, let's say you want to file a lawsuit, you want an attorney who has a really good success rate, don't you?
Mm-hmm.
Well, the same rule applies across different legal specialties. And that means that the CPS's counsel has the same mindset. And so what happens is, if you leave those opportunities open and CPS decides, okay, now we're going to order this particular service and we're going to say it needs to be our contractor, the judge isn't necessarily going to disagree. Then you're stuck with them, and their contractors tend to be more aggressive in their reporting. So if and they're more likely to nitpick every little thing. Plus, if you're choosing someone, you get to choose someone that you trust, who might not be a big fan of CPS in particular, and is more likely to side with you and your ideals. So if you've already got those services in place, most judges aren't going to be like, you know what, we'll put a redundant service in place. They're going to be like, why are you asking for this? They're already doing it. And that is a very big deal. The more that you do before they can, the more
Mm-hmm.
that you retain control of, and the better you're going to be. She's also very good at calling out CPS for what they weren't doing. A lot of people wait until the next hearing to introduce motions. They forget that motions can be filed in between hearings. You don't need to actually wait. You can get things to the judge. Orders can be issued outside of a formal hearing. And
Mm-hmm.
so that's really important. When it came to uh, communicating with CPS, she had us to run almost everything by
Mm-hmm.
to make sure that that she didn't overstep or put herself in a position where she was saying too much or too little. From motions to correct the record to motions to of placement concern and otherwise. Uh, if this information, if the information about placement concerns, if the info, if an incorrect record, if all this stuff never gets to the judge,
Mm-hmm.
then all the judge has to go on is what CPS has to say. And a
Oh.
lot of times, a lot of attorneys fail to file these motions. And so if all the judge has to go on is what CPS is saying for the most part,
Mm-hmm.
well, then how is he supposed to know that there's something wrong? How is he supposed to know that there's something inaccurate? How is he supposed to know there's another side to the story?
Mm-hmm.
He's not, because he only knows what's in record. And you have to really go at this. And honestly, this judge, although he was a good judge, he really didn't want to. When it came to the adjudication, he didn't really want to set precedent on restraint, so he tried to thread the needle.
Mm.
So no substantiation. So she wasn't adjudicated for abuse, she and her husband, but they were adjudicated for neglect.
Mm.
Now, that will eventually be appealed. And it was even with that adjudication that there was a record reunification in 18 weeks. The case closure is imminent. And honestly, CPS is so sick of this family and what they have, and we have put them through as well, that they honestly just want out.
Yeah. Yeah.
So
Persistence
case
pays
closure is
off.
imminent. They don't even want to they don't even want to show up uh, at the home. Yeah, absolutely. And in my experience, a lot of people when they go and appeal, they appeal based on the merits of the case, which in my experience doesn't often work because the how do you put it? When it comes to cases like when it comes to CPS cases, the terms under which uh, an allegation can be substantiated or adjudicated, what ends up happening is because it's so vague, it's very easy to argue that they were right, and it's
Mhm.
very and yes, that also makes it also easy to argue when they're wrong. But again, look who's in charge there. If it's a toss up, more often than not, they will defer to they will defer to the ruling that's already been made.
Mhm.
So usually most effective, the most successful way to appeal is to look for a technicality. So, for example, in your state, did they make reasonable efforts based on the definition of reasonable efforts? Did they make reasonable efforts to reunify? And can you point to specific instances where they didn't? Is there precedent for whatever technicality you are looking to get the adjudication overturned on? Is there any precedent that supports that? How effective an argument can you make?
Yeah,
This
because
case, yeah.
right.
Oh, go ahead.
Oh, there's just so much that goes into it that a lot of parents don't know about. And you, as a pro se, someone representing themselves, they know their case better than anyone else. And I think that also went in her favor because she knew her case and what was going on deeper than anyone else.
Well, that's part of it. The other part is she already had some experience with CPS. She'd already worked with us before, so
Hmm.
she had that bit of a head start that most other families don't. But the fact of the matter is, look, even if I was at the wrong end of the stick, in a CPS case, I would never face them alone because it doesn't matter how much I know. It doesn't matter how much of an expert I am. Because at the end of the day, my emotions are going to get in the way.
Hmm.
Because if it's my children at stake, I'm not going to be in an emotional vacuum where I'm necessarily going to make the same choices that I would recommend to someone else
Hmm.
in a CPS case where it's not my kids
Mm.
and the allegations aren't against me, and it's not me that might not be able to work in my field ever again. So it's much easier to help somebody else make the right choices when it's not my personal, for lack of a better way of putting it, assets at stake than it is when I'm the one at the wrong end of the stick.
Mm-hmm.
In that case, you can be the most knowledgeable person in the world when it comes to CPS. But if you think that your emotions aren't going to interfere with your ability to do everything right, unless you really don't care about your kids or your family, unless you really have no emotional attachment to them, I guarantee you
Mm-hmm.
it's going to be much easier to fight someone else's case than it is going to be to fight yours.
Oh, I can see that.
And that's why she had that's why she sought out so much support from the experts that she could find. Um, when I say don't face CPS alone, it's not just it's not just a cliche. It's not just a tagline.
Mm-hmm.
It means something. There's a reason CPS Protected Consulting Services exists. Not just that you've got a bunch of former CPS investigators who know this stuff better than almost anybody.
Mm-hmm.
It's
Mm-hmm.
that if you think that you can face CPS alone with everything that's with the personal stake that you have in it and a and get an outcome like this, or
Yeah.
what our ideal really is, avoiding the court altogether.
Mm-hmm.
I'm sorry, but you're kidding yourself.
Mm-hmm.
It's
Exactly. And Jay,
it,
where were you in 2014, Jay, when I needed you?
2014. I was graduating college.
Ah, you were useless then.
Gee, thanks. As if I don't second guess myself enough, right? You're too kind. But but the point is, through all of this, and uh, I will say, through all this, nobody keeps it together. But
Mhm,
you mentioned that a lot of families don't know.
mhm,
So I had we had another client, and I remember when she dealt with the local CPS agency a number of times, and it never amounted to anything. They didn't really do their due diligence to begin with.
mhm,
And then all of a sudden, over the smallest issue, where in theory the children were at risk, not that something had actually happened to the kids, but that in theory something could,
mhm, mm.
and the kids were removed, and there was no understanding. It's like I thought I thought this was different
Right,
than the uh, than the allegations. I thought this was just dependency or whatever,
right.
that they weren't actually connected. Well, then why did they remove your kids? Have you seen the petition that they filed? And it's not that she isn't intelligent. This client, we work mostly with primarily with women, just
Mhm,
because uh, at least in our experience, mothers have, for the most part, been the primary caregivers. So even if the father is in the picture, and we are
mhm,
working with him too, and we do have some fathers who are primaries that we work with as well. But when it comes to when it comes to this, we work mostly with women. So she, it's not that she wasn't intelligent. She was a very intelligent woman,
mhm,
but there is the tangled web that is that is the child welfare system, and child welfare litigation is so unfathomable
Mm-hmm.
in many ways that it's very difficult for anyone to digest. It's like basically trying to be an expert on every aspect of the tax code. It
Mm-hmm.
is extraordinarily complicated, extraordinarily ridiculous, extraordinarily long. It, most people don't actually understand it. Even accountants, you look at most CPAs, there's a reason they specialize. Financial services, real estate, family wealth, mergers and acquisitions, what you call it, food and beverage industry. They tend to specialize because can you imagine? uh, 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 uh,
Mm-hmm.
You're either going to be really good, you're either going to be excellent in one area, or you're going to be mediocre in every single area because trying to understand the tax code and where to get you deductions and how to best get you into regulatory compliance in every single industry uh, is really a tall order.
Mm-hmm.
And so the same issue exists in child welfare. But the difference is you have a lot less people paying attention to it.
Mm-hmm.
More people pay attention to taxes because, well, everybody unfortunately um, gets robbed on an annual basis, and they usually have to hand over the money by April 15th.
Ugh.
Uh, uh, Even if they do file for an extension to complete their filing, they do have to at least hand over the money. So, uh, there is more of a public acceptance of it and a lot less ignorance. Now, you could argue that's its own problem, but
Mm-hmm.
it's but this is why even some of the most intelligent of people will be dumbfounded
Ugh.
by what they're faced with. And I see a lot of people who say what they're doing is illegal. Now,
Right.
there are times when they aren't necessarily entirely compliant or they don't do their due diligence, but because there is a lot of these these laws, these policies are so vague, technically from their vantage point, it is legal and
Mm-hmm.
they can successfully argue that. It may be horribly immoral, morally egregious. I'm struggling to come up with the right adjective, but point is, it may be morally egregious,
Uh-huh.
but that doesn't necessarily mean it's illegal. And this is now there are some cases where there are blatantly illegal things that are done. But again, as I said in the last podcast, this is one of those circumstances where just because you can doesn't mean you should.
Right.
And even in this case, technically, the removal was legal because in such a case of abuse, reasonable efforts aren't necessarily required to keep the family together at that point, but that doesn't mean that reasonable efforts aren't required to reunify the family, especially if you aren't adjudicated in the court for abuse. So it's in that. So you have to be very careful when you say whether it's illegal or not. You need to make sure you're right.
Mm-hmm.
Uh, it When people say it, it doesn't mean they're wrong, but if too many people say it and there's scrutiny on it, what ends up happening is people take it less seriously because they're like, oh, everybody says it's illegal. How it's like how uh nobody who's in prison is guilty because everybody says they're innocent.
Yeah.
You you go
Yeah.
to prison. There's nobody who's going to say, "Oh, I'm guilty." No, they're going to say, "I'm innocent. I'm wrongfully imprisoned."
Mhm.
Why? They don't want to be in prison.
Right.
Would you want to be in prison? Come
I was
on.
there once.
Yeah, well, did you want to be there?
Oh, no.
Did you hear
No.
anybody say that they belonged in prison?
Um, no one ever said anything, but my cellmate said, well, you're here. And I said, well, I'm here because I'm innocent.
Exactly, exactly. And the last thing you want is for people to, especially with the message child welfare and child protective services are, the last thing you want is people looking at it, well, if looking at it the same way as they do people in prison. Well, if they're in prison, they must have done something to get themselves there. So they probably should be there. You don't want people looking at child welfare like they, for the most part, currently do, which is if their children have been removed, if their parental rights have been terminated, well, there must have been good reason for that. They must not be good parents.
Mhm, mhm.
It,
That's so
it,
unfair.
it, it, exactly. And that brings me to due process. Due process doesn't actually have to be fair. People think that I've run into a lot of people who believe that due process literally means fairness, and it doesn't. It
Mm,
does not mean fair. So make sure you understand exactly what due process means. Uh, uh, Certainly, there are things that aren't fair. I mean, when you're raising a kid, you may allow them to explain themselves and then rule. Not that we call it that, but that is in effect due process. It may not be fair that you're in charge and it's because I say so. And no, I don't like your argument, but that is you have in effect, if you've allowed your child to explain yourself and you've taken things into consideration, even though you have that authority, you have provided them with due process.
mhm,
Nobody thinks of it that way, but that is what it is.
mhm,
Um, but overall, I think that there, if you want the now, of course, uh, there are variations when it comes to allegations, when it comes to state, but generally speaking, if you want the best outcome available to you, I think there are a few there are a few things that need to align in
mhm,
order for that to happen. First has to be you have to be prepared before CPS even shows up in the first place. And this is assuming there's going to be a removal. The for uns for uns Although some of this is also going to apply to cases where there isn't a removal, I'm going to focus on first on those that are exclusive to removal. You have to be prepared before CPS even shows up, before they even open a case. You cannot you cannot start the preparation. You cannot start working on this when CPS shows up. If you're doing that, you're already too late for the ideal.
mhm,
When you have to, so the government measures adult literacy on a scale
mm,
of less than 1 to 6. Is less than 1 to 5. I'm sorry, it's a 6 point scale. In order to essentially do this effectively, especially if you're doing this yourself and representing yourself per se, you essentially have to have uh, be on that scale, adult literacy. You have to be at minimum at a 4, ideally at a 5.
mhm, mhm,
If you have an enormous amount of help, you can do it at a 3. But if you have difficulty reading at a higher level, particularly because a lot of this legal stuff
mm.
is very complex. Some of it includes middle terms from Middle English, Old English. There's a lot of Latin. It can be overwhelming. Um, and you have to act relatively quickly. So if you're going to do that, and your reading comprehension or your writing skills are not as good as they could be,
Mhm.
if CPS isn't involved yet, this would be the time to work on it.
I agree.
You might not even need a class. You might be able to just do it yourself. There are plenty of free courses, free classes. You could go to someone that you trust to bolster those.
Mhm,
You need you need someone else in advance to spot check you. It could be a former CPS investigator you know. It
mhm,
could be a subscription to one of the urgent assist tiers.
mhm,
Um, that could be a potential option.
Yeah, but
Working
it's
working with our consultants,
yeah.
an attorney who is really proficient in child welfare law and litigation, someone that you can essentially lean on for this type of preparation. Then you need someone with you through the whole process to make sure that you're making the right decisions,
Hmm.
that you're staying calm, that that you're doing the right thing. Then once, especially during the removal process, then you need to make sure that you're filing the right motions, or your attorney is, and you need to be predicting exactly what CPS and counsel are going to do. You need to be predicting that ahead of time. You need to be planning for
Mm.
multiple contingencies.
Ugh,
And
yeah.
and if you do that right, you can get the how do you put it? The outcome that you can get the outcome, and you can get the return in this case. But you have to be prepared. You have
Hmm.
to preempt CPS. You have to keep your composure, and you have to have the right people behind you. If you don't meet those four criteria, you are probably going to be in a lot of trouble. And I have spoken to so many parents who are deep into a case, or 6 months, a year, 2 years, or the parental rights have been terminated. And it might be recent, it might be they were terminated 10 years ago. And the conversation usually starts with them saying something like this: if I knew then what I know now, dot, dot, dot.
Hmm.
Don't be that person.
Yeah, because CPS Protect is like an insurance policy, in my opinion. If you were around and I had little kids, I would definitely have you as an insurance policy
It, it,
because they're rampant.
it, it is essentially the idea behind CPS Protect Consulting Services, and by extension, our urgent assist subscription service, was that the attorneys don't seem to really know the child welfare side particularly well. And that's a major issue. These attorneys can be extraordinarily expensive. And look, going grocery shopping has gotten extraordinarily expensive.
Right.
If that's expensive, can you imagine with an attorney who specializes in child welfare, a good one?
Hmm. Hmm.
So there are some nonprofits that, in a limited number of cases, will offer pro bono legal help. But what ends up happening is they look for the easiest cases, the ones that are most likely to change the precedent that their funders are looking for. And so you get a very lucky, very small minority, and everyone else is left hung out to dry. And most in the social services space, they're funded essentially by the government. So our thinking over at CPS Protect Consulting Services is we need to make the answer isn't to provide it free to as many people as we can, because the demand is always going to vastly, uh, you know, eclipse the supply. And so why not try and lower the cost to premium assistance
Hmm.
for everybody, and make it scalable to meet the demand while keeping it independent from government. And so, yes, we do charge, but it's a lot less than an attorney.
Hmm.
Our service is available 7 days a week, including holidays. Uh, it comes with other features. We use AI, for example, that's available 24/7, to make sure that the resources and answers are available, and it helps reduce the amount of time that you need from our consultants, which actually results in it being less expensive overall. We are, and I will give you and your listeners a sneak peek, so to speak. We have been working on acquiring motions from successful child welfare cases.
Mm-hmm.
And we are working on turning these into templates that we're looking at including in our urgent assist subscription, so that people who are representing themselves pro se, or people that have a court appointed or private attorney and want them to go in a specific direction, or they're not getting enough time from the attorney, or it's too expensive. For example, fill in the blanks, fill in what you need for the motion,
Mm-hmm.
customize the um, eh, customize the heading to what the small changes you might need to make for your particular state or county, and either give that to your attorney or submit that yourselves. Obviously, as former CPS investigators, our consultants can't provide legal advice, so to speak, but
Mm-hmm.
these templates can go a long way. There's nothing else like them
Right. It's like
available at this
limited
point.
scope.
So yeah, we are continuing to invest in more and more tools, in more personnel, to be available for families across the country. We serve all 50 states and Washington, D.C., and what the revenue that we do get from subscriptions essentially goes toward a getting these tools to market, making this accessible, and remaining independent from the government. We haven't taken out so much as a small business administration loan.
Mm-hmm.
We have no ties to the government other than our consultants' our consultants' experience as former CPS investigators. That is it. The
Yeah.
only people that we are accountable are uh, uh, that we're accountable to are our subscribers, and that's the way it's going to stay. We have actually, although it's not necessary at this point, um, we don't really have any other major investors who essentially are, uh, would have the power to change the philosophies that we have right now when it comes to parental rights, when it comes to not contracting with the government and all this other
Mm-hmm.
stuff. But we have been looking at potentially converting uh, our entity to what's known as a statutory public benefit LLC.
Mm-hmm.
And what that is essentially nonprofits are allowed to or have their own mission statement. Uh, their so-called mission that they're bound to. And historically, for-profit entities only had the only thing that they were bound to was their profit goal.
Mm-hmm.
What first the Public Benefit Corporation came out, or the PBC. The statutory public benefit LLC is much more recent, really the past 6 years. But what the PBC and the statutory public benefit LLC actually allow for is to, at least in the case of the statutory public benefit LLC, because corporations follow a different type of formation, different documentation. But for a statutory public benefit LLC, uh, those same those similar social goals or missions uh, are enshrined in the operating agreement alongside the profit goal, which means that you cannot have you have both interests, the social interests and the profit interests, must be taken into account. There's also more transparency when it comes to uh, reaching and meeting both of those goals. There is the stakeholders can also sue if there is the stakeholders in the entity can also sue if if they don't think that the social or profit goals uh, are being adhered to. it offers additional protections. We haven't really seen that it would make people more likely to subscribe to urgent assist. And since we're not really in any danger at this
Mm-hmm.
point of someone coming in and saying, no, we need to contract with the government because of the interests of profit. Um, the the only interest we would have is if it would make people trust us more, and it would bring in more subscription revenue to actually uh, put in the time and the capital that it would take to actually change the entity. But if any of your listeners would be more likely to subscribe, or they think that this is a good thing and something that we should do, I would encourage them to email us at contact@cpsprotect.com and say that that's what they want. Because the more feedback that we get on that, the more likely we are to do that sooner rather than later. And we certainly appreciate any feedback that we can get, any suggestions, and if it's within our purview to do it, certainly we will implement whatever suggestions your listeners have. If it's something that we can't do but we'd like to do, we will certainly bank it for when we can. So I would certainly encourage that from your listeners. But that's certainly um, uh, navigating CPS cases is so important, and we're proud to really be the first, and at this point, really the only entity in this space offering what we do.
Yes, an excellent service. Now, I won't keep you any much too much longer. Do you want to talk about the Chevron defense or the Chevron Doctrine and how that affects a lot of things?
So the Chevron Doctrine, the overturning of it at least, is exciting. If I still drank, I would have had a celebratory drink when I got the news. So
I did.
the,
Don't worry, I did it for you.
thank you, Marianne, much appreciated. Uh, the Chevron Doctrine, for those who don't know, it resulted from a 1984 case that went to the Supreme Court, where the Supreme Court essentially ruled that the that executive branch agencies, federal executive branch agencies, were considered experts, and if there was any ambiguity in the law, or there wasn't a law in particular that, or even if there was, um, uh, that federal judges would defer to the agency's interpretation of the law, which
Hmm.
essentially made these unappointed bureaucrats legislators.
Hmm.
And that it meant that precedent could be essentially established out of thin air just based on these unelected bureaucrats' mere expertise.
Right.
And there was there was a case that came to the Supreme Court that had that basically, I believe off the top of my head, it was a company that was doing some fishing, and they had to pay this arbitrary monthly fee that covered some expense. I didn't look too deeply into the case itself, um, and it was found that there was no law that allowed them to impose this fee, and therefore they couldn't actually do that, no matter how they interpreted it. And so, as a result, the Chevron doctrine was overturned. Now, I saw a lot of people in the CPS space, in the anti-CPS space, rush and say, "Oh, this is going to be a huge game changer for child welfare cases." The Chevron doctrine never applied outside of federal agencies and federal courts. So it does offer some exciting things for CPS cases, but at the federal level only. So
Hmm.
let's say in the state and municipal courts, if they're going by a rule imposed by the Administration for Children and Families, the federal sub-agency of the Federal Department of Health and Human Services, that essentially deals with CPS, then maybe there could be something. But this is going to have the most outsized effect in the lower federal courts, but in all federal courts, generally speaking. This is not going to apply to a state CPS agency, and I believe that New York State and California have their own deference deference laws, independent of the Chevron Doctrine.
Mhm, mhm.
So New York and California may be different stories. It remains to be seen how much of the how much this could affect the state courts or the municipal courts in CPS cases. But my prediction is the effect will be minimal, regardless. In federal lawsuits, for example, under what is it? Title 42, Section 1983 of the United States Code,
Mhm.
you might see a bigger effect there if uh, if if federal rules imposed or there's precedent with interpretations by the Administration for Children and Families, especially if they're named in particular, you could see some market changes there where federal rules and federal laws are more easily refined via these lawsuits than they have been previously. But I wouldn't jump for joy that dependency cases and the way that CPS operates are all of a sudden going to change markedly
Mm.
as a result of the Chevron Doctrine. But it is a good move for the country overall
Mhm.
beyond CPS cases. And if this starts to reduce the amount of regulation and the power of a lot of these federal entities, who
Mhm.
knows what this could eventually trickle down to, what might come as a result of this. And that may have a more outsized effect on what happens in the state and municipal courts. So I am optimistic,
Mhm.
but we need to be realistic about what, at least in the context of CPS cases in particular, the overturning of the Chevron Doctrine actually means.
Excellent. Now, how can people reach you if they have any questions?
So they can certainly they can visit us at our website at cpsprotect.com. They can uh, engage with us on Facebook, Instagram, X, or Twitter, whatever you want to call it, LinkedIn, on our pages.
Mhm.
We have some great videos on our YouTube channel. We've recently started on TikTok, but I think we're at one follower. So it's not particularly popular. But those videos that we do are all very informative. They can be very helpful. We can also be reached by email at contact@cpsprotect.com.
Mhm.
And if you're interested in learning more about CPS Protect Consulting Services or want to find out about subscribing, you can reach us toll free at 844-633-KIDS.
And I will put that all in the podcast notes, but don't jump off, okay? Slam the gavel, can't even talk. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I'm your host, Marianne Petrie. You can find me on Spotify, YouTube, Apple iTunes, Anchor FM, iHeartRadio, other platforms I don't know about. Feel free to buy me a coffee to keep the podcast going, and you can find that in the podcast notes. Thank you so much.